Joining us now to help unpack a little bit of what we've seen today, we have David Coale, constitutional law attorney. David, thank you for joining us. First of all, just walk me through what we've seen unfold today.
So the Senate followed exactly what it said it was going to do in its rules. The rules that it enacted a while back said that the morning the impeachment began, they were going to sit down and have the whole Senate go through every request made to throw out all or part of the counts. And then Mr. Patrick individually would make rulings on a number of procedural matters. And boom, 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 boom. They would write down the list, resolved all the motions, resolved the evidence issues, and took care of some more preliminaries. They were very organized. They followed tightly to what they said they were going to do in the rules, and they got the job done right on schedule.
And I know they went through the articles of impeachment. They had Paxton, his attorney rather, plead to those. What happens when they come back from break?
So it's time to get started. We've decided what we're going to try. The articles of impeachment were not thrown out. We know how we're going to do it. There were rulings on things like keeping time and on the very important issue of whether Mr. Paxton can be compelled to testify. And so there's a certain time that both sides have to make their opening statements. I believe it's an hour per side. Their counsel will address the full Senate and by video the world. And then the House managers will call their first witness. And I imagine that'll still be going on when we close for at the end of the day.
And David, you touched on something I want to dive a little bit more into. Paxton, we know now, will not be compelled to testify. Does that make any difference in this case? Does it help him, hurt him, or really affect this in any way, shape, or form?
Well, on the surface of it, it's a big tactical win for him because there were a lot of scenarios that didn't look very good for him. If he was compelled to testify and had to assert the Fifth Amendment over and over and over again as probably the first witness in the House manager's case, that wouldn't have been a good look. It wouldn't have looked good here, and certainly wouldn't have looked good played all over TV for the rest of everybody's lives. But that House, the Senate didn't go there. The Senate said he couldn't be compelled to testify. I'm not so sure I'd feel that great about that if I was Ken Paxton, because the votes today on the substantive counts, on the motions to dismiss, were all like 22-8. That's 21 is what it takes to convict him. And so when all the counts are still in by a majority that's enough to convict, and then they go ahead and make some rulings that go his way on procedural issues, that might make you think they know what they're going to do on the merits, and they're trying to take away arguments that he can make that it wasn't fair and the process wasn't good. He's getting exactly the process he wants, but he should be very concerned about where that process is going to go, given how these votes shook out on the motions.
Yeah, and to your point on that, we saw a lot of 22-8 votes. And as you mentioned, 21, that's the votes that are going to be required for a conviction. Should we read into that?
You can drive yourself crazy trying to read tea leaves in this business, and it's hard to read too much into that because it's not the same question. And the question at the end of the day of whether there should be impeachment or not is not the same question as does it pass the smell test to go ahead and have a trial about it. Those are very different matters. On the other hand, the arguments that Mr. Paxton made were points of law. The law isn't going to change between now and the end of the proceeding, and 22-8 is a strong margin. You might have thought he'd pick up a few more votes in there. If he'd been able to come in at the beginning and lose these votes, but still have 10, 15 people voting for him, he could say, guys, look at where you're going. If I can get that just at the beginning, imagine what it'll be like at the end of the day. So you can't read too much into it, but I doubt he's feeling real great about those margins all coming out with more than 21 people on the other side, because that doesn't really start him off on the right foot.
So when they come back from break, likelihood is they will start with the opening statements. You mentioned witnesses. They'll start calling the witnesses. Where does it go from here? What do the next few days to weeks look like?
Sure. The rules that we have had and that were clarified a little bit this morning say each side has 24 hours to put on their case. And that basically means time spent talking to a witness, either one who you call or examining a witness presented by the other side. It's just like football. 24 hours on the courtroom clock is not the same as 24 hours in the real world. It runs a lot slower than that just because people have to move around and objections are made and that sort of thing. But both sides have got a list of people sort of in a strategic order for how they want to present them for maximum impact, and they're going to work their way through those names. I don't know who the House managers are going to call first. There have been some disclosures about that. They may already have made a statement about that. Ken Paxton was the obvious first choice if they could do it. They're not going to be able to do that. They're going to have to go to Plan B, and there are a number of promising Plan Bs out there.
How long do you think this whole process will take?
We've got it down for a couple of weeks. These estimates, in terms of hours on the clock, are consistent generally with that. In trials like this that are complex and have a lot of witnesses involved, things generally begin to move faster after the first few days. You kind of get a sense for where things are going. You want to avoid repetition. So while it may seem like there's an awful lot to do in that couple of weeks, I think people are going to get better at it after the first couple of days. Things are going to be more efficient, and senators certainly don't want to sit around, all September if they can avoid it. So they've got a powerful incentive to get it done in a couple of weeks, just for good housekeeping reasons, so they can get on with their other business.
What is the standard of proof in this case that the senators are having to weigh as they listen to the witnesses come forward?
Good question. In a criminal case, it's beyond a reasonable doubt. In a civil case, it's by preponderance of the evidence. This is neither. This is a unique thing. It's created by our state constitution for the specific purpose of removing a government official from office. It's only happens 2 other times. For lack of any better ideas, if I was a senator, I'd probably go with preponderance of the evidence to guide my thinking, but I'm not compelled to do that. I'm compelled to cast a vote pursuant to my oath to represent my constituents and the people of Texas, and different senators may read that to require a different burden of proof.
Well, and it's interesting because I was listening to some of the proceedings, and I thought that I heard them saying beyond a reasonable doubt, but I wondered about that because this really doesn't fall into either of your categories in terms of a trial.
People have been throwing that around, the whole procedure here. And look, just because it's not a court case doesn't mean it's completely alien to one. I mean, we've been borrowing ideas from court cases constantly. The rules that the Senate put in place here look a lot like court rules. And so there's a lot of tradition and a lot of learning that can be borrowed here. And there are situations where drawing an analogy to proof by a reasonable doubt is helpful. Helps you kind of think through an issue and how it would play out. But at the end of the day, it's a question of senators casting votes in something that is fundamentally political, something that's under our Constitution. That's just a different animal than the burden of proof in a trial.
What happens if Paxton is convicted?
He would no longer be able to hold public office in Texas. Right now, he's suspended from office because of the way our Constitution is written. If he wins, he would get his office back. If not, he would no longer be on leave. He would just be out, and he would not be able to run for further offices in Texas.
How do you see this going? I know that's kind of a loaded question, but right now, from what you've seen thus far, any ideas on what you think, how this is going to play out?
So what I've seen this morning has been a Senate that is very well prepared. They were well organized. They've done a lot of homework. They didn't waste any time. People had clearly thought through whatever it was they had to think about. That's a good thing. That means they're going to move efficiently and do the work that they need to do. The House managers have had very fulsome showings in their motions they filed before this, showing all the evidence that they intend to put on, that raise some very serious questions. And you have enough senators who have been working hard because of how they voted this morning, vote to not dismiss the indictment that makes you think they might be inclined to see it from the perspective of the House managers. So my very rough initial sense is it's looking pretty good for the House managers, but it's the very beginning of the first day, and who knows how it's going to play out. That's why we're having this proceeding.
Last question I'll throw at you. The one thing that did kind of stand out to me a little bit was you definitely had a little bit of bristling between the attorneys in this. Anything to read into that?
That's just life. I mean, you've got people who are sort of professional showmen, really, really good trial lawyers. You don't get to be a trial lawyer of that stature by having a small ego or being a shy personality, and it just comes with the territory. The sort of person that's drawn to that kind of work and is very successful in it by their nature. It wants to assert themselves, wants their opinion to be known, and you're going to see some sparks fly. You just are.
Any last thing that you think people should be watching for or anticipating as we watch this process unfold over the next couple of weeks?
One thing I'll be interested to watch is this business about Mr. Paxton testifying. Of course, he can't be compelled to testify. He can still do it if he wants to. I doubt he's going to want to because of his criminal cases. But since he can't, he's not likely to actually be on the witness stand. I think the House managers are going to go to another page in sort of the standard litigation playbook, which is the empty chair. I mean, he's not an empty chair. He's sitting there. We all know that. But if he's not talking, it may as well be empty. And I think there'll be a lot of witnesses that talk about things that they heard from him, that they saw him do, and sort of draw attention to the fact that he's not testifying when it might be interesting what he has to say about that. I think you're going to see it'll be a subtle thing, it'll be in the background, but I think these are really good trial lawyers and they're going to make as much out of this empty chair concept as they possibly can in their presentations.
David Coale, constitutional law attorney, we appreciate your insight on all of this today.
Thank you very much. I appreciate you calling up.